So before my campaign issued that ad, my opponent sat for an interview with Channel 2 News. He had the full opportunity to discuss the incident that happened 40 years ago. He had, and he did. He discussed it at length. And I watched his interview, and what he basically said, he didn't dispute anything in the factual basis of the charges that he faced. There's no question that he was arrested for driving while intoxicated, for fleeing the scene or resisting arrest, and felony assault of a police officer. What he said in that ad was, I should never have been driving, I made a mistake, I got a second chance, and I availed myself of a plea offer. A plea offer, by the way, that when I am district attorney will not be available. If you assault a police officer in a traffic stop, we're trying that case. After that ad, after he gave that interview and acknowledged those criminal charges, we issued an ad. And I believe that ad is factual. It's factual in the charges that he was charged with. And just because my opponent accepted a plea offer to a non-criminal disposition doesn't mean that he didn't commit those crimes. That happens every day in Erie County. We offer, the justice system functions on the idea that not everybody pleads to the highest sustainable charge. Oftentimes we know, the proof shows that they committed those crimes, and we offer them the option to plead to a lesser charge.
Thank you. Mr. Keane, you have 2 minutes to respond.
So I accepted responsibility for my mistake. It was 40 years ago. I was 21 years old. I was a senior in college in upstate New York, and I pleaded guilty to a non-criminal violation. He's characterized it as a crime. He characterized me as a criminal. That is false. The reporter that did that ad called it misleading. The Channel 2 News reporter, or the Channel 7 reporter, called it false and called it a lie, because that's what it is. They put a current picture of me up there and suggested that I'd just been arrested. The charges involving the assault were dismissed. They were dismissed by a judge. There was no plea deal. It was not part of the situation. I pleaded guilty to a non-criminal violation, and it was 40 years ago. I made a mistake. I owned up to it. And by the way, Charlie Specht from Channel 2, who's in the room today, was provided the report by my opponent's campaign. It's a sealed record. It was sealed by a judge over 35 years ago. My opponent is ignoring a court order sealing a record, and he's using it for a political advantage to try to discredit me. I went on to get my law degree. I went to graduate school. I've been a lawyer for 31 years. He wants to talk about something that happened over 30 years ago, almost 40 years ago. It is a false ad, it's misleading, and it's been rejected by not only the legal community, but everybody that I meet in this community. And one of the things that you should know is that you are going to make mistakes. Your friends and family are going to make mistakes. You are going to have adversity in your life. And you should be able to get up, clean yourself up, and move on with your life. That's what I did. I've accepted responsibility for it, for my opponent to try to use this to his political advantage when he's violating a court order, knowing the records are sealed, and he provided them to a media outlet to try to take advantage of it, is wrong. It's inappropriate, and it's outside the appropriate conduct, not only in a campaign like this, but he is an attorney. He's under an obligation not to behave in conduct that is deceitful.
Thank you. Due to the nature of this video and the seriousness of it, I'm going to allow each candidate a rebuttal now that they've heard each response. So Mr. Gardner and Mr. Keane, you have an additional minute to respond to the story that was aired.
First of all, my campaign obtained that record legally. Channel 2 News also obtained that record legally through a Freedom of Information Law request. My opponent has a problem with the fact that we found the record. He has a problem with the idea that Channel 2 News obtained the record. His issue is not with me, it's not with Channel 2, it's with the town of Colony that obviously didn't didn't seal the record. I have done nothing wrong. My campaign has done nothing wrong. Channel 2 has done nothing wrong. The only person who's done something wrong in this matter is my opponent. He broke the law. And I understand he wants to say that it was 40 years ago. But what do you call somebody who breaks the law? How can you, as the chief law enforcement officer, deny a defendant accused of the same conduct, the same plea offer that he himself availed himself of? You can't unless you...
Thank you. Thank you. Mr. Keane, you have a minute for a response.
So, Channel 2 obtained the report from my opponent's campaign. County town attorney then told my opponent's campaign that the record was inadvertently disclosed and it should be destroyed. I've seen the letter. They have it. They're ignoring it. They're continuing to use the ad and violate a court sealing order. If you are going to violate court orders, and my opponent works for a judge, if you are going to violate court orders and continue to do that, that's the kind of judgment that does not belong in the district attorney's office. I have never been convicted of a crime. For him to characterize that as me being a criminal is completely wrong. People that get accused of crimes have their charges dismissed. Those assault charge was dismissed, not by me, not by my lawyer. They were dismissed by a judge and by the prosecutor. That's what happened. I was never convicted of a crime, and for him to characterize it that way is false. It's misleading. And that is, we take a specific oath as lawyers to not engage in conduct that is misleading and deceitful.